We're just gonna wait for a few more seconds before we start, guys. Hello everyone and welcome to SCO's live daily updates. I'm R. Sai Spandana. I'm an associate editor at Supreme Court Observer. Today we're going to be talking about two cases that were heard by two constitution benches of the Supreme Court. The first case was heard by a bench led by Chief Justice D.Y. Chandrachud. This concerns the applicability of the group of companies doctrine in arbitration cases. Essentially, in this case, the main question is whether parties that have not signed an arbitration agreement can be bound by the agreement because they belong to the same group of companies as one of the signatories. We've previously spoken about this case in our other live sessions, so I highly recommend you visit those pages as well. But the bench continued to hear the parties today. Senior advocate Darius Kambata represented one of the parties in support of the doctrine. He essentially stated that the doctrine can be applicable in India, but it cannot go unchecked. It must be governed by the contours of the Indian Contract Act. More specifically, Section 7 of the Indian Contract Act. This section states that acceptance of an agreement must be very, very clear, absolute and unqualified, which means there cannot be any doubt that one of the parties intended to be a part of this agreement or contract. So he said, when we apply the group of companies doctrine in India, we must give party autonomy and party consent a lot of importance, and the doctrine must be governed by these contours of the Indian Contract Act. And he said that if the doctrine is unchecked, it can cause a lot of problems, and a lot of people will misuse the doctrine, and India will stop becoming, there's a potential threat that India will stop becoming a arbitrational hub going forward. So some of the checks Mr. Kambata recommended are from a report that the UN Secretary General had previously written on the applicability of group of companies doctrine. Remember that this is not an exhaustive list, but some pointers recommended there were, firstly, to assess the intention of the parties in the contract, to see how the party has performed. Just the fact that a company or a party has been a parent company of one of the signatories is not enough to establish that they intended to be a part of this arbitration. Right, some other more indicative factors like their performance, how involved they were with, say, hiring or other essential operative decisions of the company matters. So he said these need to be considered while applying the group of companies doctrine in India. And he also stated that the burden of proof is on the company that wants to invoke this doctrine. After Mr. Kambata presented his arguments, Mr. Rai represented SAP, and he said that in this present case, SAP was not governed by the group of companies doctrine because they were not actively involved in any of the interactions between Kings and Cox India, who are the petitioners in this case, and SAP India. Now, moving on to the second case, a 5-judge constitution bench led by Justice K.M. Joseph heard the parties in the challenge to WhatsApp's privacy policy in India. Essentially, the petitioners in this case had challenged WhatsApp's 2016 and 2021 privacy policy, stating that it breached the user's right to privacy. The petitioners also stated that this privacy was against principles of international law and equity because the privacy policy WhatsApp had in India was very different from the policy it had for users in Europe. The petitioners claimed that users in Europe had a higher degree of protection than users in India, and this was wrong on WhatsApp's part. This case was previously heard by the bench on 1st of February 2023. That time, Solicitor General Tushar Mehta, representing the union, stated that the Digital Data Protection Bill of 2022 was going to be introduced in the parliament in March of this year, that is last month, and this bill would solve a lot of the concerns raised by the petitioners in the case. So he requested the bench to not hear the case till the data protection bill was presented in the parliament. And so the bench decided to wait till the protection bill was tabled at the parliament. Of course, the data protection bill never made it to the parliament in March. But today, Attorney General of India, Mr. R. Venkatramani, represented the union. He stated that the bill was complete and he assured the bench that it would be presented at the parliament in the monsoon session, which starts in July of this year. It's important to remember here that two of the judges on this bench, Justice K.M. Joseph and Justice Ajay Rastogi, will be retiring in June. So taking into consideration these factors, the bench stated that the most practical solution would be for this case to be posted sometime in August of this year, after the digital data protection has been tabled at Parliament. So they recommended that the registry list this case before the Honorable Chief Justice in August so that he can create a different constitution bench if necessary and take the case forward. Senior advocate Shyam Devan was also present. He represented the petitioners and he seemed very unconvinced. He tried to tell the court that judicial proceedings should not be linked to legislative processes because legislative processes are very abstract and uncertain and they have like a journey of their own. However, the bench, with all due considerations, has listed the case to be heard in August this year. So these were our top stories today. Do follow our social media pages for more latest updates from the Supreme Court, and also log into seobserver.in for more updates. We will see you again tomorrow at 5 p.m. Thank you.